Right, you can approach and proceed.
Thank you, Your Honor, and may it please the Court, Jeff Yeomans for Amazon. We're asking the Court to vacate a citation that the Department issued to Amazon under the emergency shower standard because the Department failed to prove that a shower was required as opposed to emergency eye wash. I want to begin by talking about this concept of the zone of danger. It's something that the parties have briefed extensively. In preparing for today, it occurred to me that I think the parties got a little bogged down in that issue, maybe in a way that's not helpful to decide this case. So I want to start by acknowledging that our employees work in close proximity to corrosives. That's what they do in the cage. We're not denying that. So in that sense, they are in the zone of danger, right? But that doesn't answer the question in this case, because the question in this case is, what type of emergency washing facility is required, right?
Is the most problematic word for you on this record the word potential? I mean, that's pretty broad.
Right. Yeah, I think, Your Honor, it needs to be interpreted by the Court, right? I mean, we disagree, obviously, with the Department that the plain language rule applies there. There are different interpretations you could give to the word potential. One possible interpretation is if it's at all possible, if it could happen, right? And that's what the Department argues. Another, I think, more natural interpretation, especially when we're talking about what kind of washing facilities are required, is there a reasonable likelihood, right? And by that, we're not arguing that it has to be likely or probable or 51%. We're just saying if all you've got is a possibility, if all you've got is we can't rule this out, that's not enough to trigger the shower requirement.
So what about the possibility of a corrosive spill on a concrete floor, someone sits and falls in it, saturates their clothing? Don't they need to rinse that off pretty fast?
Right, so there is a possibility, right, that you could have a spill, Your Honor, and I think the key to figuring out what kind of facility is required is looking at the volume, right, of the products that these associates actually handle, right? When you look at the language of the standard, right, it's talking about major portions of your body. That's the difference between an eye wash and a shower. That's got to be talking about quantities. And so the question is, well, how do you really look at the quantities in this case? What quantities are we talking about? The Department, of course, wants to aggregate everything, right? The Department says, thousands of pounds of corrosives are processed through the cage during the course of the month. That doesn't tell you anything about the actual risk that the associates face, because obviously they're not processing thousands of pounds of corrosives at the same time, right? It's undisputed, and this is the key fact in this case, that every single item that goes through that cage is a consumer item, which means it's consumer-sized, which means it's small, which means if it does have corrosives in it, it has a small amount of corrosives in it, which means that if there is a mishap, right, if something's dropped or it spills or whatever, there's a limit on how much volume is going to get out of that container that could possibly go on that associate.
If I slip in a puddle created by a gallon of bleach and I fall on my tail and soak my pants, don't I want to wash that off?
You want to wash it off, absolutely, Your Honor.
Right. A gallon is not an insignificant, and it is not a large quantity. I mean, you have lots of gallon containers of bleach go through this facility.
Right. So the problem with that, Your Honor, is then there's no limit, right? We know from the standard that the standard does not intend to require an emergency shower in all situations when corrosives are present, right? We know that. Otherwise, it doesn't make any sense. So we've got to interpret this major portions of the body language in some reasonable way that will allow us to distinguish situations where an eye wash is enough, and we did have an eye wash.
So an eye wash doesn't help my scenario. I fall on my tail in a gallon of bleach.
Right.
Eye wash has nothing to do to help.
Right, right. That's right. I mean, you could have a situation where an eye wash is not enough with a gallon of bleach, but if that's the interpretation you adopt, then a shower is going to be required in any workplace as a practical matter where corrosives are present. I mean, any workplace has a jug of bleach in the janitor's closet. You're also going to have an eye wash within 50 feet of everywhere that janitorial staff work and use cleaning products.
Do we exercise any deference here? So do we say that the right way to figure out where that line is that
Right.
you're saying needs to be drawn? I mean, do we say that falls to the department and its inspectors? Because, I mean, the difference with the janitor and the bleach in the closet is the janitor's using the bleach periodically from time to time, as opposed to having a primary job function of handling the jug of bleach over and over and over and over again all day. So would we defer it all to the department saying you need the shower in one situation but not the other?
So a couple things, Your Honor. First of all, the difference, that's a key difference, right? Janitors actually use the product, so actually their exposure, there's an increased risk of exposure there as opposed to processing things
Well,
that
you
are
could argue it
enclosed.
both ways, which is why I'm asking, is the department in a better position to draw that line in individual cases than we are?
So the question is, where is the line? I mean, we're now up to the Court of Appeals, and the department has yet to articulate where that line is. We've had this janitor scenario out there the whole time. They've been very dismissive of it. They have yet to explain why their interpretation would not require a shower under that. So I think if you're going to defer to them, first of all, they have to articulate some principle, right? Some line that would allow you to figure out when is an eye wash enough, right? And then second of all, I mean, to the extent we're looking at frequency, the language of the standard is not based on frequency, it's based on volume, right? The distinguishing language is major portions of your body, and that's what we have to be talking about here is the quantity, these individual items that they're handling, is that enough to present some reasonable likelihood? The other thing I wanted to quickly note.
But again, here, I raised the gallon of bleach, but again, here, we're taking a gallon of bleach and more gallons of bleach and more gallons of bleach and filling 55-gallon drums, and that's what we do all day long in this cage.
Right.
It's not the janitor's facility, the janitor's situation. It's here, it's multiple bottles of bleach are available. All it takes is one to create a problem, but we're handling multiple bottles of bleach a day. I mean, I'm just using bleach as an example,
Yeah.
but the job is to fill 55-gallon drums of like materials, I assume.
Right.
So they can be shipped off.
Right, yeah.
So we're going to have up to 55 gallons of bleach
So
moved during the day.
and I'm sorry, Your Honor. Right, so you're talking frequency, right? Once you're talking about how often they do it, you're talking about frequency,
And
right?
quantity.
If the standard is probability, then it doesn't matter whether you do it once or 10 times or 1,000 times. So if we're talking about frequency, we would welcome that, right? Because that goes to this idea of whether there's a reasonable likelihood. And what the federal cases have said on that is if you have a situation where something is frequently done without incident, that's actually evidence that an emergency shower is not required.
All right.
Thank
you
you.
very much.
May it please the Court, Will Henry on behalf of the Department of Labor and Industries. So the board correctly found that Amazon needed to provide an emergency shower to its employees working in its hazardous waste area. And this court should affirm for two reasons. First, the emergency shower regulation, as was discussed, applies whenever there's potential for chemical contact with an employee's body. And under the regulation's plain language, as Amazon apparently is conceding today, there is no requirement that chemical contact be likely to trigger the emergency shower requirement.
I don't think they're conceding that. They're saying it has to be interpreted that way. What counsel posited was reasonable likelihood. In his parade of horribles would have been this, or what we're going to do here if we side with you is require every QSC to have a shower available to consumers that wander down the aisle where they sell bleach.
Well, and I think it might be worse than that. I mean, we probably have something like it upstairs in the court's kitchen. I mean, we're going to need one too, aren't we?
Your Honor, so this would be, so That's not the case before you, of course. This is a.
Well, it's a hypothetical.
It is a
That's,
hypothetical.
That's the whole idea
So
behind
let me-
hypotheticals, Mr.
And
Henry.
it's not just a hypothetical, because the issue was actually addressed in the record. The department inspector was asked specifically about whether non-leaking containers of bleach would pose any risk, pose this potential for employee contact with hazardous chemicals. And she indicated no, that the risks were simply not present when you're dealing with situations where there are non-leaking bottles of bleach. So the situation here in Amazon's warehouse, of course, is that the packages are going to the hazardous waste area specifically because they are leaking. And so there's an entirely different set
So
of risks.
before they became leaking containers, were they potentially leaking containers?
So
I mean, obviously so, right?
as the department inspector testified in the record, that would not pose the potential for contact with hazardous chemicals.
Well, so
I
how
would
do-
say that, yes, Your Honor.
But how does what you're saying translate into a rule that we can write that interprets the law and draws the line somewhere?
Well, here, the question is whether substantial evidence supports the board's determination in this particular case. And in this particular case, the board properly interpreted the word potential to mean existing impossibility and having the capability of developing into actuality. And under that standard.
How do they come to be at this location, the different items? Are they sent from retail establishments? How do they come to be there?
In the warehouse? So
Yeah.
it's an almost 1 million square foot warehouse that's filled with these kinds of items, some of which contain.
So these have
hazardous-
never made it to a retail store.
No, that's correct. It's in a warehouse.
And so people come upon them.
So when an item spills or is damaged, that usually happens somewhere on the floor of the warehouse. And there's a set of employees who are set to go and clean that spill up. At that point, there's a whole series of procedures that Amazon has to slowly, from station to station, to sort, depending on what the product is, into different waste streams. And for corrosive materials or materials that are deemed hazardous in some way, they end up eventually in the hazardous waste storage area, or what Amazon calls the cage. And that's where that was the area where the inspector identified.
So if they don't leak in the warehouse, your witness testified they have no potential to leak anywhere else.
That was the inspector's testimony.
Is that sensible?
So long as I think it draws a fair line. So when an item is not leaking, when it's in its normal container, there's just not the potential that product is going to get onto an employee's body in
So
a
we've got two
significant way.
bottles of bleach. One of them is discovered in the warehouse to be leaking. Its potential to leak was manifest. But the other one has no potential to leak
Well,
because it hasn't leaked yet.
Well, the potential is not that we're talking about is not the potential to leak. The potential that we're talking
Well,
about
that's the
is
first step to getting on an employee.
But the right, yes, Your Honor. But the potential that's discussed in the regulation is the potential for major portions of the employee's body to contact the hazardous chemical. I'd also note that the focus here today appears to be on whether major portions of the employee's body had the potential to contact these chemicals in the hazardous waste area. And the department, the board properly interpreted that portion of the regulation, that major portions of an employee's body had potential to contact these chemicals.
Is the word potential used elsewhere in the administrative code provisions that apply to the department?
I would not be able to say for certain. I would imagine that the word does appear in other areas as well. I'm not aware of any.
If we were to discern whether that was true or not, would that perhaps inform our analysis of what the word means?
I'm not aware of any Washington appellate decisions interpreting the term potential in other portions of the code. But again, as I stand here today, I cannot say with certainty whether that word does appear elsewhere in the code. So again, the interpretation makes sense with regard to major portions of an employee's body.
When the department drafts regulations, does it follow the guidelines of the legislative code reviser, or does it go its own way? There's a code reviser that has guidelines, and we can look to that sometimes to figure out what statutes mean. Regulations are authorized by statute. My question then is that the same, is the same source looked to guide word usage?
I am not certain, Your Honor.
Okay.
I'm not certain with regard to that question.
Don't we need to look at potential in context, though? It's a potential for major portions. I mean, it's a whole sentence. It's a potential for major portions rather than parse it. So isn't the difference here that a gallon of bleach in the janitor's closet versus a cage that's accumulating up to 55-gallon drums of leaking bleach bottles? Isn't that the difference?
I think that is clearly a difference.
Again, it's a case-by-case analysis. In this case, this cage is collecting large quantities of leaking bottles and putting them together.
That was the entire purpose of this hazardous waste area, was to accumulate the leaking packages in one place so that they could then be processed by a third-party contractor.
I mean, are we really looking at this as a legal question or a factual question, right? I mean, is it our job to announce an interpretation of the rule, or are we just asking, did the trier of fact here have evidence to find that the rule wasn't followed?
Your Honor, I believe it's a mixed question of law and fact. The term potential, what the meaning of that term is a legal question. But in terms of the facts on the ground, that is certainly a factual question, and the court would look to the substantial evidence review standard for determining whether that standard was met or not. Unless the court has any other questions for me, the board properly determined that the emergency shower regulation applied here and that Amazon failed to follow its requirements. Substantial evidence supports the board's finding on employee exposure when employees worked in direct proximity to these hazardous chemicals around the clock, processing thousands of pounds in that area per month. And the department would ask that the court affirm. Thank you.
Thank you very much.
So, Your Honors, the janitor situation, again, the janitor opens the bottle of bleach, opens the cleanser, uses it throughout the day. There's clearly a potential in the sense of a possibility
But
that
again,
that will
there's a
spill.
huge factual difference between 1 gallon of bleach and purposely loading up to 55-gallon bottle drums of leaking bottles of bleach.
Right, but the exposure, Your Honor, and the critical fact here is it's not when you open the drum up, it's not a combined, soup of corrosives. These are all individually packaged, and if they're leaking, and not all of them are leaking, individually bagged products. That's what the associates are actually handling. I would agree with you. If we had 55-gallon drums that were just full of liquid corrosives, absolutely we would have a shower in there. What's unusual and unique, and I think decisive in this case, is that it's undisputed that all these items are individually contained. They remain individually contained, and if leaking, they remain bagged throughout that process. And so again, if the standard is a reasonable likelihood, if the standard is possible, I don't have anything to say to you, but if there's a reasonable likelihood standard, it's not reasonably likely in these specific circumstances in this case because those items always remain separately packaged.
Can the potential language in the rule be the standard? I mean, if we review a jury verdict on a breach of contract case, we don't engage in a philosophical discussion of, well, what does breach really mean? Because that's defined. I mean, why don't we look at that? Why don't we look at it and just say potential is the standard, and it's up to the trier of fact to determine if the evidence meets it?
Well, potential is the standard, but, I mean, the whole issue, Your Honor, is what does that mean? Is the standard any possibility, or does there need to be a reasonable likelihood? The last thing I would mention is the department's own directive on this, which is still on their website this morning, says that there needs to be a reasonable likelihood that there will be contact with the chemicals. We're just arguing for the standard that they've had on their own website for the last 11 years.
Got it.
Thank you, Your Honor.
Thank you, Counsel. All right, the matter is submitted, and we've got a couple minutes, so we'll be at recess.
All rise. Court is in recess.